What's up, guys? Welcome to this video on the last payment by Amir Law. I read this book last night, and it talks about mastery. And in order to master something, you've got to repeat it. You've got to read it over and over and over again. And so I thought today I would reread this book because it was very powerful, very simple, and I just thought, hey, what better way to really skyrocket and exponentially increase my knowledge on this book than to make a video about it, read it out loud, and kind of go off on tangents because I've actually been on this journey for well over 10 years, going down, the path of secure party creditor, private, unincorporated common law trust, going private, stop using the social security number, building business credit, all these different things. And this book and this topic of subrogation and substitution, to me at least, it makes perfect sense. And from what I've seen, it is highly effective compared to, arguing or, trying to use, bonds or anything like that. If it's a criminal case with the GSA bonds, I just think it's a very powerful tool because at the end of the day, guys, you've got to remember that we have the power. The power is ours. Okay, the power is ours, but that system, as my man Yusuf El would say, it is demonic. Okay, the vast majority, I would say 9 out of 10, public servants, all the way from Supreme Court judges, all the way down to a parking enforcement officer. Okay, they are possessed. They are low level, low consciousness, low emotional intelligence people. And God bless them. I hope they learned their lessons in this lifetime. But it's like Jesus says somewhere in the Bible, to paraphrase, I'm not a scholar, but, he talks about going into the where, the money changers are and the lawyers. And, when he flips over the desk, he talks about, those are the most wretched of the people, those who seek and lust for power over other people. And so their world is, one of corruption and manipulation and conspiring. Okay, whereas with subrogation, substitution, and with I think Amir, what he's teaching is the law of is equitable law, equity. See, they don't want equity. Okay, they want manipulation. They want control. And so a big shift that I've seen happening, because remember, I've been in this for over 10 years, is a big shift is happening where people are, they are seeing through the lies, they're seeing the corruption, and they're taking their power back. And, it's very, very powerful stuff. And so, I know this book it helped me out tremendously. I just understand what the strategy of, subrogation is. It's really not that hard. It's empowering yourself. It's taking back your power. And it's, at the end of the day, it's having a script, because it is a circus. It is theater. All of it, from the symbolism of, crossing the fence, okay, to the black cloak that the judge wears. It's all a show. It's all a facade. It's all fake. But it is based. But if you consent, if you acquiesce to it, then hey, you volunteer. And like he says in here, if you're the voluntary surety, okay, you will put up your body as collateral, for the debts and the obligations and the liabilities of the estate, the straw man, the all caps name. So it's really all about, one is having your script, knowing a subject such as this, such as subrogation, substitution, and it's studying this, it's listening to a video like this, and then it's, being prepared to go and stand up for your rights, your birthright. That's what this is about. It's about taking back your birthright. We have all the power. We truly are the creditor. That's all true. as far as going out and setting up, a treasury direct account and trying to get something for nothing, I'm not really into that, but I am into equity. I am into freedom. I am into justice. And I think that the justice system is very unjust. It's very corrupt. And so, this topic in particular allows us to take our freedom back. It allows us to balance the scales and to create an even playing field. Although not easy, it definitely can be done, and more people are going out there and showing how it is done. And so I very much appreciate Amir for writing this book. It's very, very simple, but very, very powerful. And yeah, I just, after reading it last night and going through his child support class, the little, video series that was up last year, I took a lot of notes. I drew a lot of diagrams that I'll share with you, either in this video or in a thread or something like that. I don't know. Just to kind of show you what happens before subrogation and then after subrogation. Okay, and how, again, like he says, when you step into the roles of the creditor of the state, okay, and you take control of the situation, then it really is very, very powerful stuff. And so when you can see that diagram, it really helps things click. But again, reading this last night, it made it click even more. So without further ado, let's hop into this. The Last Payment, a guide to terminating child support. And I would say, really a guide to terminating any public dispute, anything like that. Okay, so let's jump into this. Copyright. I'll send this to him before I, put it up. But okay, life is a blank canvas. It's the part that you fear because it's the unknown, but you're the artist. The canvas is only blank because you haven't created something yet. It's no reason to fear the unknown. It's reason to create the picture you want your life to be, so that every time you sit back and reflect on that canvas, you can appreciate the work you've done. Amir Samael. Common knowledge is detrimental. Specialized knowledge applied to real life situations is better than any currency. Very true. Okay, there's simply no substitute for reading, so read this ebook. Gain special knowledge that only the top 10% of people in the country are utilizing. Take your time and read to understand so that you become one with this knowledge. Stay focused for 3 to 6 months and watch your life change. So right here, big key word, become one. Embody this. Embody this information. Make it become one with you. When you embody it, it will empower you, and you will then take back your birthright. You are the creator. Okay, table of contents. Okay, introduction to suretyship regarding terminating child support. Suretyship, let's get to it. So, suretyship is an agreement where a third party known as the surety agrees to be responsible for the debts and obligations of another party known as the principal debtor. This agreement provides a level of security to the creditor, ensuring that the debt will be paid even if the principal debtor fails to fulfill their obligations, like someone like co-signing on a loan. Okay, exclusive equity principles govern the suretyship agreement and ensure fairness and protection for all involved parties. Understanding the parties involved in suretyship. We have 3 parties to every transaction, every single transaction. Now, who is the principal debtor? That is the name on the birth certificate, the driver's license, and the social security number. That all cap name, that straw man, that estate, whatever you want to refer to it. But in suretyship, we're going to refer to it as the principal debtor. The principal debtor is primarily responsible for debts and obligations. It's the one that's receiving the charges, that has the charges. Who is the surety? The government, the state of Indiana, the state of California, the state of Florida, Georgia, wherever you live, that is the creditor. And they are implying that you are the surety for the principal debtor. Again, you are being implied as the surety for the principal debtor, which is the name on the birth certificate. And the creditor is the state of wherever you live or wherever your case or business resides or the jurisdiction thereof, and the representatives for it. So that will be the judge, the clerk, any intermediaries, any of them, any prosecutors. They will represent the state of wherever you live, and they will be considered the creditor. Okay, equity principles in suretyship. Equality of burdens. So under this principle, all parties involved in suretyship in a suretyship agreement should share the obligations and risk equally. The surety should not bear a disproportionate burden compared to the principal debtor. The principle aims to prevent unfair burdens from falling solely on the surety and promotes a balanced distribution of responsibilities. Consent and full disclosure. Importance of full disclosure and consent. It's vital that the surety enters the suretyship agreement with full knowledge and understanding of the terms and conditions. Informed consent is necessary to ensure the surety comprehends the risk and responsibilities associated with the agreement. This principle emphasizes the importance of transparency, ensuring that the surety is not misled or coerced into assuming the role of a guarantor without complete understanding. So again, because this game is built on it's a voluntary game. When you go in there and you don't even understand all of these different positions and how they work, okay, you are taking on the role of the guarantor of the principal debtor. You're saying, hey, I am the surety. I'm the one responsible. I'm the cosigner. Okay, violation of full disclosure. Do we ever get full disclosure? No, we don't. We never talk about rescission, regulation reforms, never really telling us the mode of the contract. That's it, not even really a lawful contract, that we are giving up our rights, our equity. None of that is in the disclosures that we do receive. So therefore, we're not receiving a full disclosure, and whatever else that we don't know about the case or the story behind it, like every case has a bond. So that's already a violation. What I'm explaining to you guys is that all parties must be transparent with each other, must act in good faith. If that doesn't happen, then there's an issue. Just like real life. If you and your friend go in on a deal, or you and a few of your friends go in on a deal, and two of your friends are making deals on the side but don't tell the rest of y'all, that's not full disclosure, right? You're not going to appreciate that. Essentially, you might be like, give me my money and I'm done. I'm out of the deal. I'm out the deal child support. It's the same thing in court. But again, if you don't ask, okay, I'm dealing with a child support case right now. If you don't ask for good faith, if you don't ask for full disclosure, and if you don't stand and demand that and go through and go through the process and the procedures on how to do that, then how can you expect to get it? Okay, understanding child support in the context of suretyship. Okay, equitable subrogation under exclusive equity jurisprudence. Equitable subrogation is a principle that allows the surety to step into the shoes of the creditor and obtain all the rights and securities that the creditor had against the debtor. So again, the creditor is the state, okay, and the debtor is the all caps name. Okay, so by expressing and invoking your right to subrogation, okay, now you're changing up the roles, saying, hey, I'm going to step into the roles of the creditor, okay, and I'm going to take control of this matter of business. Okay, in other words, the surety acquires the rights to pursue remedies available to the original creditor, including collateral or liens held by the creditor. Okay, you as a surety are stepping into the shoes of the creditor, and you become the subrogee. You don't become the creditor. Again, you become the subrogee. By expressing and invoking your right to subrogation, you as the surety are stepping back and say, hey, I'm not the surety. Okay, I'm going to be the subrogee. So I'm going to take over and I'm going to manage this thing. Okay, you don't necessarily become the creditor. However, you are stepping into the shoes of the creditor. So don't get that mixed up. Never say you're the creditor. Okay, creditor and debtor, that's a public relationship. Okay, we are on the private side now. Okay, again, their whole game is based on black magic, word magic. That's why Black's Law Dictionary, black magic. They have, numerous definitions for words. So we don't want to go in there and say, I'm the creditor. Okay, we're going to send them formal notice saying, hey, I'm invoking my right to subrogation. I'm stepping in as the subrogee. Okay, Your Honor, you're going to be the trustee. Okay, and, prosecuting attorney, you're going to be the creator of the trust. Okay, that's a public relationship. We're on the private side now. So in equity, this is how you want to go about it. Remember, you step into the shoes of the creditor. The surety becomes the subrogee. Now, those same rights that the creditor had against the principal debtor, okay, the state versus the all caps name, okay, Idaho child support, Utah child support, okay, Florida child support, that's the creditor, okay, the principal debtor is that all caps name that comes in on the case or the presentment. Okay, now you have those rights because you're stepping into the shoes of the creditor. So who's the creditor? That's the state of wherever you live and all its representatives. So it's like you're stepping into the shoes of the government. Remember, the government is we the people. But when you voluntarily give up your right to contract, your rights to subrogation, okay, understanding contribution in suretyship. Contribution. So sureties are entitled to seek contribution from co-sureties if they end up paying more than their share of the debtor's obligations. If there are multiple sureties, each one is generally responsible for an equal portion of the debt. If one surety pays more than its share, it can seek reimbursement from other sureties in proportion to their liability. Okay, on the child support order, whoever's signature is on there is charging. Okay, that means that they are responsible for making sure that debt gets paid, whoever is signing as the obligor. Okay, we'll go into that in a minute. Okay, because when you sign that, if you sign that order, that's a contract. You're signing that contract saying that, hey, again, I take responsibility for the principal debtor. I am the principal debtor, okay? And I'm responsible for paying that debt. But now the principal debtor, it's that name on the birth certificate that everybody does, they're going to be co-sureties. So they are your co-sureties. So if you're invoking your right to equitable subrogation, then you can seek reimbursement from your sureties. Now I know that y'all have seen one of the testimonials where he's basically explaining that's how he terminated his child support, by making a few phone calls to the clerk and expressing this to her, calling her up and say, hey, I'm calling, invoking my right to subrogation. Okay, so there's a script. Again, everything they do is a script. Everything you've got to do is a script. Okay, subrogation and contribution rights. So contribution and subrogation rights. So if the surety pays the debt on behalf of the principal debtor, the surety is entitled to seek contribution from the principal debtor. That means if you, the private person, or the private man or woman, person, we're not persons, right? Okay, you as the private man or woman paying those, Federal Reserve notes on behalf of the principal debtor. Okay, once you go through this, you can say, oh, hey, I've paid on that behalf. I need a refund for all those Federal Reserve notes. Okay, this means they can recover the amount paid from the principal debtor. Additionally, the surety may have subrogation rights, allowing them to step into the shoes of the creditor as the subrogee. Okay, let's read that again. Additionally, the surety, you, may have subrogation rights, allowing you to step into the shoes of the creditor as the subrogee and pursue equitable remedies against the principal debtor, your all caps name, and against the creditor that becomes the subrogor, who are both responsible for reimbursing the subrogee. Again, remember, these are co-sureties. Okay, you're the surety, the implied, almost the unaware surety. Okay, on behalf of the principal debtor, you're paying your child support every single month. Blah blah blah. Okay, thinking that you are the all caps name when you're not. Okay, all the while the state, again, Utah, Idaho, California, the Department of Health and Welfare, whoever, all of them, they're all in cahoots. Okay, they're co-sureties. But when you discover all this and go back and say, oh, I made a mistake, we'll talk about that here in a moment. I need to get reimbursed, because remember what it says in equity, if we're all partners, you, the living person that's literally giving your life force energy, that is the credit that runs the whole game. You've been out there working, putting in your life force energy to make those, Federal Reserve notes, and you've been paying. The scales are tipped. Okay, the principal debtor and the creditor, okay, who's been paying out that social welfare to the mother, to the child, and also to the fathers. His father's on child support. Okay, anyways, okay, you've been paying into that, and these guys, they're pulling this out of thin air by creating bonds and all this other bullshit, and then they're trying to collect that money on the back end through you. Okay, so they got to reimburse you for all that money you put in. Okay, the subrogor becomes the trustee in equity. So again, the creditor, the judge who is representing the state, as well as the prosecutor, who, if they are representing the state, health and welfare, child support, recovery, any of those other names that they have for, it's essentially just McDonald's or some credit, collection agency. Okay, they become the trustee. They're holding securities in trust for the benefit of the subrogate, who is the beneficiary. Now, these rights enable the surety to prevent unfairness or unjust. Also, that's why the subrogor must reimburse the subrogee to prevent an unjust enrichment. Unjust is unfair, enrichment is payment. So again, the state, okay, they ain't working for free. It's on a non-profit organization. Again, they're debt collection agencies. They are making money on fees somehow, some way. Okay, and the judge, okay, they're all in cahoots. They're all making money off of this. So because you've been the only one paying those Federal Reserve notes, that's unjust enrichment. When you're invoking your right to equitable subrogation and they don't want to perform, then it is actually an unjust enrichment. You can be exonerated for that. You can file a bill in equity. So again, the principal debtor, that's the all cap name on all business that comes into your mailbox. Everything's, and even if it's a variation thereof, it's still, they are referring to as it will say here, a legal entity. A legal entity. It is not you. Learn how to not associate it. Change your name in your mind and in your heart. So my all caps name is Gary Gilgan. Okay, but I go by just G. That's it. So all my friends, the people close to me, they call me G. I don't go by that name because it is not me. I'm trying to distance myself in the private, the public entity that I use. Sometimes I barely ever use mine. In fact, I never use it. Okay. It's the all cap name on the birth certificate, driver's license, social security card. Look at the back of your social security card. It's not even yours. It says return this if we ask you to. Okay. You're the surety for that name. You're the co-signer. If you're saying, hey, I'm the surety, if you're not expressing your rights to subrogation, then you're saying, hey, I am liable for all debts and obligations of this all cap name. Okay, the government is the creditor. when you, as the surety, invoke your right to equitable subrogation and substitution, you are stepping into the shoes of the government and you become the subrogee. Okay, the state and its representatives become a subrogor. So again, the state and even the representatives, because remember, all lawyers they are bound to the court. They are court officials. They do not work for you. They all become a subrogor. The whole game changes when you invoke this. You have your script. You stand on your square. You know how to play the game. You can fight through the emotions that you're going to feel. And in equity, the subrogor is the trustee holding the securities. Remember, in trust law, the trustee is just the manager, just like the manager of McDonald's, baby. Okay, they're just here to pay bills. So when you invoke your right to subrogation and substitution, you're changing all. It's like, let's look at like in baseball. Okay, the judge is the umpire. Then you've got, maybe the pitcher is the prosecuting attorney, and then uh, if you don't invoke your right, you're the at bat, but you have a major disadvantage. You're like someone that's an absolute pro, the very best pitcher ever, compared to someone who's never played baseball, like myself. But when you do this, you change the whole role by taking on, hey, not only am I the umpire, okay, but I'm the coach, I'm the captain, I'm the owner of the entire team, baby, and I'm changing all this. So now you pitcher, you're a subrogor, okay, your honor, you are now the subrogor, and we ain't even playing baseball anymore, baby. We're playing kickball. I'm about to kick yo guys' ass. Okay, holding the securities in trust, meaning bonds and things like that, and trust for the benefit of the subrogee, who is the beneficiary. Okay, demanding release in suretyship. So demand the release, demand the release. The suretyship agreement, this is what you are going to file with the court. This is your script. This is your script. You should know this thing inside and out. The suretyship agreement should include provisions for cancellation and release, allowing the surety to be relieved of their obligations under certain circumstances. These circumstances should include the repayment of the debt by the principal debtor or the fulfillment of the agreed upon terms. This principle prevents the surety from being indefinitely bound by the agreement, ensuring that their obligations are terminated appropriately. So, when you step into the shoes of the creditor, you become the subrogee. You're not the creditor, you're just stepping in. You're just a substitute. You're just a substitute of the creditor that day. You are the subrogee. You want to demand a release. Okay, what is a release? That's when the subrogee orders the creditor, the subrogor, to discharge and extinguish the liens and obligations against the debtor, your all caps name, and subrogate, and restore to the subrogee the creditor's secured interest, okay, in all subrogee securities. Because again, that contract, in a court order, is a security. Okay, the order that you have, okay, from the court with the judge's stamp or signature, that is a security. They're sending you a copy. They keep the wedding signature at the court. Okay, that thing's worth a lot of money. Okay, securities of accounts of the principal debtor. So essentially, that's saying you need to hand over the securities that are held in trust to me, the subrogee, and I am the beneficiary. And those originally came from the principal. Okay, defenses and rights of the surety. So defenses and rights of the surety have certain defenses and rights that can protect their interests. For instance, the surety can demand collateral from the principal debtor. Okay, what is collateral? Something you put up in case you can't fulfill a credit obligation or an obligation in general. Okay, as security against potential default. Additionally, the surety may have rights of set off. What is set off? Okay, enabling them to offset their obligations with any amounts owed to them by the principal debtor. These defenses and rights are crucial for the surety to mitigate risk and ensure their interests are protected. Some of the defenses can include the sureties may raise certain defenses against the sub-brokers. That might be subrogrees or subrogors. Maybe this, I don't know, this book might be have like been speech to text or something, I don't know. Seeking to enforce their rights. These defenses could include if there's a lack of notice. Okay, so if they gave you no notice, remember, we always give notice, so we always go through the administrative process, giving someone 3 chances to be in honor. Okay, so if there's a lack of notice, if the subrogor, again, if the subrogor failed to notify the surety in a timely manner of any default by the debtor or changes to the original agreement, the surety may have a defense against subrogation, aka exoneration. Okay, so they're making mistakes all the time. Again, in the case that I'm working on right now, this case has been going on since 2019. Big mistakes made. Okay, the judge has gone through and made changes to the original agreement without my express permission or even knowing. Again, lack of notice. Okay, tons of violations, which again, exoneration. So, if the terms of the original agreement between the creditor and debtor are materially altered without the surety's consent, so I was just talking about, the surety may be released from its obligation, also known as exoneration, also known as a discharge. Fraud. If the creditor, the court, or debtor engages in fraud that affects the surety's obligations, the surety may have a defense against subrogation. I don't know what that all. I don't know. Say it with me: exoneration, discharge, illegality. Okay. If the underlying obligation or contract is illegal or against public policy, the surety may be released from its obligations. One more time, say it with me: exoneration, discharge. Very important words. Okay? If there's any funny business, which their game is full of funny business, that's the whole game is funny business, you know? If there's not full disclosure, if there's not transparency, if they fail to perform on your stipulations, then it's exoneration. You're discharged from the manor. However, there is a process to all of this. It is a game. It's a game played on pieces of paper. Okay, child support. In the context of a child support order, it is important to clarify the roles and terminology used. Typically, the individual responsible for paying child support is referred to as the obligor, while the parent receiving the child support is referred to as the obligee, which means typically the fathers. You're going to be the obligor. The mother is going to be the obligee, typically, but not always. Okay, the obligor is the principal debtor, the all caps name. Remember, disassociate from that. That is not you. You are just there to perform business on the behalf as the implied surety, invoking my right to suretyship, okay, subrogation, substitution. I'm coming in not as the principal debtor, but as the surety, stepping into the role as the creditor. I'm not the obligor. I'm not the principal debtor. A surety, on the other hand, is a third party. You, the living being, The living man, the living woman, you are the third party, the implied surety, who agrees to be responsible for the payment of child support obligations in case of a default by the obligor. You, the surety, are responsible, secondarily responsible for the child support. The birth certificate is primarily responsible. See where I'm going with this? Okay, you're the co-signer. Okay, but we're going to get rid of this altogether. You're saying, hey, if you step in as, hey, I'm the implied surety. I am not the principal debtor. I am not the obligor. I am the implied surety, invoking my right to subrogation and substitution. As soon as you make that statement, that declaration, that affirmation, and you stand on it, the whole game changes. And you might have to do it 3 times, just like Dorothy clicking her, shoes 3 times. Again, these guys are satanic. They are demons. Okay, you've got to play their game. It's magic. You need to learn how to cast spells yourself. And sometimes a spell takes 3 times or more for it to be effective. The birth certificate is primarily responsible. Okay, so similarly, a subrogor refers to a party who has the right to step into the shoes of another party and pursue remedies or claims. So, in that context of child support, a subrogor might be an entity or agency, child support services, the state of, wherever you live, that takes over the obligee's right to receive child support. Remember, they are third-party debt collection agencies. The obligor is the child's other parent. Okay, and when you go to court and you fill out they do all their financial mumbo jumbo, and they determine how child support works. You are entering into a contract with the obligee, who is the other man or woman. You're not the parent. Okay, another word. Okay, and because if they just came to get the money, it's you go kick rocks, So this child support services, they were invented as a third party debt collection, and they're going to try to go after that money because they're giving the money to the other parent, God, I mean, what word do you use, right? The other man or woman, okay? They're giving it. They're paying. See, but if you don't pay, they don't pay. They'll still give like food stamps. They'll still give Medicare, Medicaid. They'll still give all of those social benefits, but actual cash, okay, they're getting that from you. So if you don't pay, they don't get paid, but they can still get, the EBT. They can still get the food stamps. They can still get that support on that end. And that's what the state is essentially trying to do with these third-party for-profit organizations, is to receive some of that money back from you. It's a tax. It's a hidden tax on men and women. That's exactly what's going on right in child support. The state is stepping in. This was a mind-blowing part that really put things together in my mind, and it really it made things more clear. And again, when things are clear and you can see it from a new perspective, then you can be empowered and take responsibility for it, okay? And that's exactly what subrogation, that's what equity is. It's taking responsibility, without a doubt. Okay? The state is stepping in and coming after you, the father in most cases, or basically the obligor, the person that must pay. This is occurring in situations where the obligee is the mother that you are paying, the person that is receiving the payments, right? This person is receiving public assistance or support from a government agency. So they give that support, whatever it might be. Sometimes it's cash, sometimes just a card that you can go get food with. And then they're coming after you trying to get reimbursed for that. That's what's happening. The government is a separate agency. They are manipulating the situation to get you into these unjust contracts. They're stepping in and coming after you, the father. You, the person that must pay child support. Remember, the person is the all caps name. It is the principal debtor person. Okay, make sure you double back and read this. Again, yes, when you understand, and again, I created, visual, just very simple diagrams to understand it. Again, the obligee in certain situations, when the obligee, the parent with custody of the child receiving the child support payments, receive public assistance, the entity aiding such as a government agency or program may have the ability to seek reimbursement from the obligor for the assistance provided. This is known as the right of subrogation. So they're already doing it. The state is also utilizing the right of subrogation here. So they're doing it. So you're just doing the same thing that they're doing. You're just flipping it onto the judge or the representative saying, yeah, you know what? Hey, man, go get that. Go get it however you're going to get it. Let's double back on subrogation. Okay, so subrogation allows the entity providing public assistance to step into the shoes of the obligee. And so it's like your baby mama, baby daddy, they are the obligee, and they have a private assistant helping them get that money. That's why it's such a popular thing to do, and it's so demonic. And seek reimbursement for the financial support they have provided to the custodial parent. Essentially, the entity becomes a subrogor with the right to collect the child support from the obligor. So they have the right to collect from the father in most cases, or whoever the parent required to make child support payments. Let's get into the subrogee versus subrogor. The surety becomes a subrogee. So you become the subrogee. The creditor, the government, becomes a subrogor. The subrogee's rights are higher than the creditor's rights, higher than the subrogor's rights. So, in exclusive equity, we always prevail as a subrogee/beneficiary. If a surety makes a payment on behalf of the obligor, the surety can become the subrogee. This means that the surety will step into the shoes of the obligee and have the right to seek reimbursement from the obligor. Roles are reversing. In this scenario, the entity that provided the public assistance, which was initially the subrogor, the government became the subrogor. Then the government would then become responsible for reimbursing the surety who became the subrogee, which would be you, the one who made payment on behalf of the obligor. So essentially, when you as a subrogee invoke your right to equitable subrogation, then you step into the shoes of the state. Now the state becomes the subrogor. You're the subrogee, they're the subrogor. And they are responsible for reimbursing you. That's why we can get child support terminated. They don't want to reimburse you, especially securities, which are bankrolling the entire court case. They'd rather just terminate it. But you can still go after it if you want to fight, even after they terminate it, but just before you walk in and give notice. Exoneration and suretyship. The surety has certain rights and conditions to protect themselves. One of the rights is the ability to stipulate or set conditions for their obligation. If the surety has stipulated specific conditions, such as requiring the creditor to perform certain actions or meet certain requirements, and the creditor fails to fulfill those conditions, then the surety may be exonerated or released from their obligation. This means that the surety, you, is no longer responsible for fulfilling the guarantee. Discharge. Under exclusive equity jurisprudence, the surety has a right to request the court to compel the debtor to fulfill their obligation and relieve the surety from any responsibility. Now remember, the debtor is the all caps name, the name on the birth certificate, and that birth certificate is a bond. It has a lot of power. It has a lot of, value. I would go so far as say it has infinite value. A life does, and all you're doing by invoking equitable or exclusive equity, you're telling the court, hey, I need to be reimbursed from the principal debtor from this bond. I've been paying, the scales are tipped in my favor. I need to be reimbursed for that money. So you need to go get it for me. This is known as the right of exoneration. If the debtor can perform their obligation, the surety can avoid liability. So essentially you're saying, hey, you're telling the government, hey, you need to sue the principal debtor, that the birth certificate, which is the birth certificate. And of course, when they sue the birth certificate, I don't like how it says you're going to invoke your right to equitable subrogation, right? You're going to hammer them down with suretyship. You're going to settle the matter. That's why I like being in court. Handling matters in court because it gets done instead of playing around on the outside. If they don't compel the debtor to fulfill the obligation or bring them into court, then you're exonerated. Exoneration refers to a court order that discharges a person's liability. The action of absolving someone from blame, vindication, the release of someone from a duty or obligation. We're talking about the obligor versus the obligee here, right? This means someone has an obligation. The obligor has an obligation to make payments to the obligee. The father has the obligation to make payments to the mother, right? To take care of the baby. That's an obligation here. Exoneration is you being released. You are being terminated. It should be ringing bells for you. If the principal debtor owes money and the person, the entity, which would be the creditor, the state, wherever you live, right? If the principal debtor owes money, the all caps name, and the state agrees to give it to them or agrees to give them more time to pay, like an extra 30 days or extra 60 days, whatever the case may be, but never let you as a surety know or that you didn't agree to it, then that could cause problems for you, and then you're exonerated. You don't have to pay anymore. So let me break that down to you in a different way, so to think about it like this. Let's say you and your friend, y'all went and bought a new, I would assume it says Escalade, from the bank. Everything's going good. Now, if the bank and your buddy come up with a deal on the side and make up a whole different agreement and they never tell you, you're going to be mad about that, right? You're not going to like that. You're going to feel like they snaked you. You're not going to feel good about that. You're going to consider yourself exonerated from any debt and obligations. That's the same thing here. That's what I just explained to you. Okay? You know how when you call into the car lot, or maybe you call into the court and say, I need an extra 30 days to make this payment on child support or whatever, and they say, all right, that's cool. I'm going to make a note in your account, extra 30 days. Now, when you did that, you called in as the principal debtor. When you call in and you're not expressing or invoking your right of subrogation and substitution, then they are assuming, see, you're just using their games against them. Okay, you didn't call as a surety because you're just now finding out about suretyship, and the state or public can't see the substance in you being surety. When you're acting as the principal debtor and the state bank have that conversation, y'all injured the surety because you were acting as the principal debtor. So you can act as either, as long as you and let everyone know, you give notice that, hey, I am acting as the surety. I am invoking my right to equitable subrogation. I am not the principal debtor. But if you don't say that, if you don't get noticed, then everyone's assuming that you're volunteering as the principal debtor. You didn't call in as surety because you're now just finding out about this stuff. When you're acting as the principal debtor to the state, they think so too. Because they injured the surety because the surety wasn't on the phone. Remember, you can't be two people at once. You haven't figured out all three parties technically are their representative, the court clerk, anyone that works for the government, okay, they are a juristic person. So they are automatically in the matrix. They're an agent automatically. So they think if you don't invoke this stuff, if you don't start casting spells and using your power, your magic, then they're assuming that you're going right along with their plan. So never can all three parties be on, because you can't be the surety and the principal debtor at the same time. Okay? It's never going to be present because the principal debtor is nothing but an entity. You are a real man or woman, and the creditor has real representatives, but you're wearing two hats. You can't appear to be both to the state at the same time. You must switch hats. Therefore, all three can never be present. Therefore, the surety is always going to be injured. Therefore, you can always become exonerated. Insolvent principal debtor. When the birth certificate is shown to be insolvent, I ain't got no money, I ain't even got a bank account, then the surety is discharged. Example, I, the surety, under legal compulsion to do, hereby having made all the payments for and on behalf of the principal debtor since the beginning, do notice all parties that I am subrogated to the rights of the creditor in this and all transactions. This is very powerful. I would copy and paste this. This should go into your notice. Okay? It's basically saying, hey, the debtor isn't solvent. There is no money. This thing doesn't have, if you've gone through and you're private, meaning you're operating through a trust, you've copyrighted the name. I think that's super important, is, a common law copyright of your name in all capital letters. Very, very powerful right there. Whole new game. Okay, right there. You're saying it's insolvent. It doesn't have any money. It doesn't have anything. The debtor can't make the payment obligation. So you did so as a surety, and you're segregated to all the rights of the creditor. You step into the shoes of the creditor as a subrogee. Example, I, the surety in this matter, for my own protection, do hereby make the payment to protect my private person property. Okay, private person property, especially once you have, filed a common law copyright. Common law is private, more private law. Okay, so I filed that, and a person is a legal entity, which is also property, as the surety to the principal debtor. Furthermore, give notice that I, as a surety, am the subrogee. Remember, these are very bold statements you're making. Stand on your square right here. This is very powerful. And that you, the bank creditor, because that's all court is, just a bank, or the government, state of, are the subrogor. You have hereby notice of my sole exclusive act to subrogate you to my rights as the surety. Very, very powerful. I would copy and paste this. I would memorize that. I would definitely have that in my notice. Okay, that's an example of you coming as a surety and saying that. The principal debtor is insolvent, that you have made the payment on behalf of the principal debtor and are invoking your right to equitable subrogation. So again, entire good faith is required between all parties, right? Between the principal debtor, the surety, and the creditor. So did the creditor, the state of, do anything do any act affecting you? Did the creditor omit to do any act affecting you? Was a creditor required to do anything by the surety? You Did you appoint a creditor when you tendered special deposit? Or did you deliver a special deposit to settle? Did you demand discharge as a surety to the creditor? By the way, the special deposit would have been that. Special deposit is a, like he says, ability or bill in equity, okay, a negotiable instrument to discharge. Okay, did you stipulate the injury that would occur if promissory notes, okay, or negotiable instruments? Okay, did you stipulate the injury that would occur to you if the creditor did not certify your right to equitable subrogation? Okay, so we talked about earlier, unjust enrichment, okay, effect to your good credit, your unlimited credit and reputation, your public reputation. Okay, that is injury. Or if they didn't apply the promissory note as an exchange, the bill of exchange, or the bill of equity, excuse me, or didn't apply that special deposit to balance the ledger, did you tell them how that would be injurious to you? Or how an unjust enrichment lies against them? Did you tell them you would be exonerated if they didn't perform on your stipulations? Okay, balance the ledger. The judge is not required to be a witness or bring pleadings to the court. They are the referee in a sense. The receivables are the charges against the principal debtor. Okay, receivables means a bill. Okay, the bill, and then you charge the person. Okay, this is the bill that charged against the person. Okay, the bank has receivables. Okay, and those are charges. Think in terms of accounting, just like I was just thinking. If we have any people on here like that, we don't bring in an offsetting claim under the rules of procedure. The judge does not have to do the set off unless you raise the issue or defense. We have the right to waive it. Technically, you waive your assets when you don't get a receipt or perfect your interest in them. When you sign that traffic ticket, did you give notice of equitable subrogation? Did you sign as a surety on behalf of the principal debtor, all rights reserved, without recourse? Did you put fiduciary relations in the margins, special private priority? You could write all over that ticket. It's a contract. And when you take it over, you're the holder in due course, and you can write all over this before you give it back to that scumbag, with all due respect. The assets, the documents you sign, or the child support order, that has the value. That is the security. The order, the document you sign, as soon as you sign that, you are giving your credit. The offsetting claim, that's the subrogation, substitution, and release or exoneration. That's what we're going over today. You're pretty much made it to the end. Proud of you, because guess what? Majority of people are not going to make it this far. Only like 1% of people even make it to the end and even complete the task. If you made it this far, give yourself a pat on the back. It's a little bit more now.